Hi, everyone. Harry here with a sort of emergency talking feds conclave with some very seasoned hands. The reason I wanted to do this is because it strikes me that the opinion by Judge Cannon, it will be impossible to do it justice in the kind of sound bites on the cable shows. And it's we four and others like us who are going to have to do that. So I thought we could at least have a forum for treating it in more nuance, because it strikes me as very deserving or necessary to treat it that way. Anyway, let me just introduce the very estimable group that's come together so quickly. Thanks to all of them. Ryan Goodman, everyone knows everyone, but Ryan Goodman, who's professor at NYU Law School and founding co-editor of Law and Security. Asha Rangappa, who is the at the Jackson School at Yale and a frequent contributor to both CNN and MSNBC these days. Norm Eisen, who among his many hats is a former prosecutor, which maybe matters the most here. And it just struck me that besides that, it's very hard to capture this. I just tried on CNN in a 20-second soundbite. There were different views. And so let's start here. This is just a conversation. I'll try to keep it going, but I've heard a fair bit of sentiment already on the initial kind of opinions about the Cannon order of, it might not take so long, and the 11th Circuit is risky, and maybe the DOJ can live with this, and it's not such a terrible opinion. I'm already on record very much against that view, but does anybody have that view that, could be worse, not such a bad result for the DOJ and the country? Sounds like no one. And Norm, I know you've put out your basic view already, fast as you are. What's your thinking?
There's a little piece that is not so bad, and that is the order to have the special master review the 500 or so attorney-client privilege documents. That's within the range of reason. Right. The precedents go both ways. But I think for the rest, what's lost here, Harry, is that the president was in possession of over 100 documents that jeopardize our national security, jeopardize the lives of Americans and their allies if they get out. These are some of the most closely held secrets we have. And the judge under Rule 41G is actually contemplating the possibility of returning those to the alleged malefactor. And she acknowledges how dangerous they are, because she says the intelligence community can continue to review. That is a startling and illogical position that is emblematic of so many other things, respectfully, that are wrong with this. And I should add, I say that as a former impeachment prosecutor and somebody who was in charge in the White House of helping administer the Presidential Records Act and restructure the classification system, which still, the Obama version still remains intact. It is internally inconsistent and illogical.
Yeah, not just the possibility. She's got to be saying the likelihood, right? Even though she then says, well, it's very vaporous how he could have a right. I'm sorry. Ryan, Asha?
So yeah, I agree. I think it's just remarkable that here we are talking about a motion to return property, and the property is obviously highly classified information. Like, how are we in this world? So I agree with that. And then also, just to get to your point, Harry, I think it is a catastrophe, and I don't know how the DOJ doesn't appeal it. I think they basically have to, because we're sitting in a situation in which she has basically said, if some of this material is reviewed by Justice Department, FBI people, who then it could be privileged, then it taints them and they should be taken off the investigation team. So how on earth are people like Lisa Monaco and others supposed to do the intelligence community damage assessment in the meantime? That's question number one. And question number two, this could go a long time. The parties don't decide together who should be the special master. She decides. The person needs to set up shop. Person needs to determine their views on executive privilege and the like. It just seems crazy. At least, appeal the injunction. At least appeal the injunction as it applies to classified information, because otherwise, I think it's highly unworkable. And to think about the intrusion into a damage assessment that is trying to deal with the current national security risks from the leaks from the leak of this information seems to me something that has to be arrested.
Yeah, I found it very odd that she bifurcated the investigation from the damage assessment, even though those are both things that are taking place in the executive branch, and as though those aren't interdependent to some degree. And this idea, and Ryan had tweeted about this last week before her order, just this idea of slicing and dicing the executive branch, where executive privilege will apply in some parts of the executive branch, but it doesn't apply in others. And it's just a very bizarre application of the principle. Um, certainly undercuts the idea of the unitary executive, which conservatives are, I thought, were on board with. But also, to the executive privilege point, I don't understand her analysis at all. She invokes Nixon versus GSA, I think, in completely the wrong way. It really stands against her. It stands totally in favor of the government. But in any case, to the extent that that contemplated competing executive privilege claims between the former president and the current president over presidential records, that was precisely the issue that was intended to be resolved by the passage of the Presidential Records Act. In other words, there's legislation now that speaks on that. And, DOJ didn't make this argument and she didn't engage it, but in many ways, this is a situation where the executive branch is acting with legislative authority in terms of asserting where the proper ownership lies, which is essentially the full force of the government. If you use, in legal terms, the Youngstown analysis, it's the highest tier of government of executive power. And she's basically saying that this rando on the street has a claim that can challenge that.
And I just want to add the one thing that Ryan's sort of third point. Oh, and he's got to figure out the standards. That's, to me, both legally and practically humongous. Here's a guy, he's a special master, quite respected former federal judge. He looks at it, one of the 10,000 plus documents, and he finds it subject to executive privilege. Now what? At most there's a person on the Supreme Court who says there are weighty questions about how it might apply, whether a former president can ever say anything. Of course, we already know the Supreme Court already said, not here there ain't, not where Biden has waived and there's an ongoing criminal investigation. It really should be all shut down. But let's say there were. That's going to have to be, developed, I think, all the way up to the Supreme Court. In other words, a special master can't call balls and strikes here because we don't know anything about the field we're in, much less home plate. And until that's all developed, so even leaving aside the legal ungainliness of it, it seems to me time-wise, that itself, if this really goes forward, and I'll just state my bottom line view that Ryan, has to be right. They've got to appeal. But if it went forward, it's easily, a year or more just to figure out the standard that a special master should be applying. Or, am I missing something?
No, you're not missing something. I think the only way friendly amendment,
go for it,
Harry, that I would
You actually gave me the friendly amendment that she was going to do exactly this when I, in Pollyanna fashion, said, "Oh no, not this." So your amendments are well taken.
There are three on the podcast who can vouch for my predictions of this keyhole in the case law through which she's attempting to squeeze. What I just wanted to take. I just wanted to take your very lawyerly analysis and put that in the context of the extraordinary challenges that come for me that when you're attempting to hold a former president accountable. And one of the concerning aspects of this opinion was that she over and over again, for example, on page 10 says, as a function of plaintiff's former position as president,
Yeah.
the stigma is in a league of its own. No, a president is not entitled to a league of their own when it comes to the rule of law. And so I think there's a larger, and that point is made in different ways. And I really think that the lawyerly considerations need to be supplemented by all of us taking a step back and noting how challenging it is to attempt to investigate and perhaps prosecute a former president. But what's really at stake here is not just some refined legal principles about what standards will apply. It's about the ultimate standard. Is a president going to be subject to the same rules as the rest of us? Because Harry, Ryan, Asha, if any of us had done a fraction of this, we would have not only been subject to search warrant, but we would have been prosecuted long ago.
And we couldn't have pressed any of these rights until we were, of course. What about that? It's under the rubric of inherent supervisory authority under Rule 41. But I'm staying lawyerly, although also with Norm's greater point in mind, the supposed irreparable injury analysis, the supposed likelihood of success analysis. Again, when you zero in on what really matters here, the executive privilege things seem like completely slanted, you could put it, or result oriented, or indefensible. What were your guys' thoughts about the whole equitable analysis, standing even? It's that little sliver again and again of personal effects, which, by the way, are completely proper to take in the search. That then gives rise to this mountain of possible claims about the thing everyone cares about, as Ryan was just emphasizing. These documents of grievous risk for the national security.
Yes, I thought it was. I think it's tendentious, and you can see it in the rendition of facts that she gives.
Yeah.
There's also this one just unbelievably remarkable sentence that I think is a eye opener for where she's coming from. She says, plaintiff, in other words, Trump. She refers to Trump's, quote, stated reliance on the customary cooperation between former and incumbent administrations regarding the ownership and exchange of documents, this is a guy who's been obstructing the ability of the National Archives to get the stuff back, so that he had to be subpoenaed and then a search warrant. Not that he was relying on the customary cooperation as though the Biden administration was somehow violating the usual comedy between administrations. That's Newsmax level analysis. And so there's that part, and then the substantial likelihood of success. So she has to prove that there's a substantial likelihood of success on the merits for Trump on executive privilege, but her own opinion, she doesn't go into executive privilege. She punts on it. She even says, arguably, there might be an argument for it. And even though I recognize he doesn't have a strong argument, it's about a possible argument. Well, that's not the test. And, as I said in another tweet, Biden has spoken about the general approach to these documents. The May 10th letter from the National Archives, which she is aware of because she refers to it, but she doesn't refer to its content. In the May 10th letter, the National Archives says President Biden has delegated this decision to the archives in consultation with the Office of Legal Counsel, and that it is not a close case when it comes to the January batch of all the documents that were turned over then, the boxes. They can go to the FBI for its investigation. She has to deal with that. That shows that it's not a close case. There's no substantial likelihood of success on executive privilege. And then, as you say, Harry, she's bootstrapping on the basis of the personal belongings and the potentially privileged materials, which, it's not even 520 documents, it's 520 pages.
Right.
Of potentially privileged materials. On the basis of that, we've suspended the core part of a criminal investigation and an espionage investigation. That's where we're at. I think that's the legal reasoning, to get into some of the legal weeds of it as well.
Bootstrapping really is again and again we have this move of, he's got an interest in these few effects. Again, no one says they were illegally seized. Again, he can get them later. he may have that. And then this huge, it's the ultimate to me, tail wagging the dog opinion, because when it comes time to then talk about likelihood of success on what really matters here, it's, well, maybe down the line, we could find that I mean, I'm not exaggerating. Although the government argues he has no property interest, calls for an ultimate judgment on the merits as to those documents. That's what we mean by likelihood of success. It might, you might change it later, but you actually say, is he going to win? Not could some court somewhere think there's an argument to be made.
Did I miss something? Because I don't recall Trump's lawyers asking for an injunction in their original request. And
right, and they backed away
they
from
made-
executive privilege, correct?
Yeah,
Yeah.
it was kind of an afterthought. I think, in one of our earlier discussions, Ryan mentioned that the judge had to prod the lawyers about that. And even on this 4-part Ritchie test, I recall the Trump lawyer saying, yes, we can brief that for you if you like. So she actually just made their argument for them. They didn't even have to do anything. And the injunction piece to me is just really problematic because I think there's a separation of powers issue there.
Yeah.
In that
Explain.
she is essentially paralyzing a key function of the executive branch, which is to take care that the laws be faithfully executed. There is a place where courts enter that picture, in terms of allowing the government to use what they gather in evidence as against a defendant. But she seems to have greatly overstepped her bounds in just completely putting a stop to even the
I mean, the place, to be clear, is when someone is charged. All these rights he can bring up if and when he's charged.
Well, then he has
Yeah.
reputational harm. That was the
right.
other crazy town piece of this opinion, which is, we can't wait until he's indicted because he might suffer irreparable reputational harm. But my question is, isn't that true for literally anyone who's charged with a crime?
Everyone with an escutcheon, or
Also,
what was that word for a family crest? Yeah.
Compared to your average defendant,
Escutcheon.
I would
Isn't
say
that
that this doesn't the marginal harm to his reputation is, or the harm to his reputation here is marginal, since everyone already assumes he's a criminal.
All right, we just have a few minutes, and I think we've done. I almost wish there was someone here taking the view of no, don't appeal, but it seems like a total forced move to me on sort of 3 or 4 different levels. Anyone have any other sort of nuggets or specific things to offer at the kind of level of nuance, as that just are not going to be coming out? We can safely predict, having done it for a few years in our quick hits on the cable shows.
The decision whether or not to appeal is an agonizing one, because there's so many unknowns. We're not privy to every detail of the case, and the question DOJ must confront is, will there be more harm to the interests of justice in this case and writ large if they roll the dice on a special master, as opposed to ripping the Band-Aid off now to establish those standards and the parameters? I don't think that's I incline towards appeal, but I don't think that's an easy call.
Because you foresee the possibility of a worse 11th Circuit decision. Although this is certainly law of the case, right? This is not a small case here, just the effect.
No, but you could get a worse 11th Circuit decision. Conversely, if you wait, you might end up, and there's disagreements over the special master, then it has to be resolved by Judge Cannon, then it goes to the 11th Circuit. If that ends up taking many months, you might wish you had established the principles or ruled the whole special master out from the get-go.
Yeah. I mean, it just seems, it's not just even the special master. To me, what underlies it must be some notion of some kind of possessory interest here, and that's got to be faced sooner or later, because that tubes the whole damn thing, it seems to me. Asha or Ryan, any nuggets you want to raise here? You think about it while I say one thing, which is it was footnote 13. And what does that say? Yes, it is so routine that when you do a filter analysis that you do things that are possibly get through. But what she doesn't recognize is when that happens and when you try to use those, a defendant can jump up and down and cry holy hell, and whoever has seen them is no more on the actual trial team. So there, as if there was some special sloppiness or failure of the taint process here. I think there's a lot of places where she just doesn't seem to have dealt much with criminal cases.
Sure, and I'll riff off of that. I think that footnote might be showing where she's going next. If she were trying to unravel this investigation, then it sounds like she thinks, and as long as she has control over the case, if there were other pieces of material that should have not gone through to the investigation team, and the special master determines that, then it taints those people who have seen it, and they shouldn't be on the investigation, which could include the deputy attorney general, right? So it's that, I think, is and I think she's maybe laid that so that she can in the future refer back to that footnote. I have to think that's highly likely given how tendentious the ruling is.
All over Northland. But right, applied to the deputy. Okay. Well, that's I know we'll be piecing that. I hope we can talk more about this, but I'm really glad to have out here something that explains why, in a nuanced way with both law and practicalities, this is a mess. Norm, Ryan, Asha, thank you so much for joining on so quickly. And if any of us, it doesn't have to be for Talking Feds, wants to return the favor and just get together, I'm in.
Thank you so much. Great to talk to you.
Thanks so much.
Thanks, everyone.